Hi, my name is Jin Hee Lee. I'm a business attorney, the partner of Lee and Song, and the founder of Keller Consulting. My practice mainly focuses on M&A and business transactions with Korean companies. Actually, I had practiced in Korea at a big law firm as an M&A lawyer for 8 years and moved to LA and registered to the State Bar of California as a foreign legal consultant. From today, I'm going to talk about M&A. And today is the first day. So the topic is what is the M&A? I'm going to talk about the keyword and then the types. Okay, the keyword. M&A stands for merger and acquisitions, but it doesn't fully explain the M&A. So what's the keyword? If someone asks me, I say it's the change of control. The change of control. What is the control? I think it's the authority to make decisions on the management of companies. Usually, to get this authority, you may have shares over 50 percentiles that the control. So, pretty simply, M&A is the transaction to cause the change of control. For example, if you buy shares of a company from someone who is a majority shareholder and then you become the majority after the transaction causes the change of the control, so you can say that the transaction is the M&A. And next, before we talk about the types, we should talk about the components. Generally, we can say the buyer, seller, the target, the price. So you can also put it this way. The M&A is the transaction that the buyer buys the target from the seller with the price. Specifically, the target, it could be the share of the company, business of the company, and company itself. And the M&A types are varies in terms of the targets. We can divide the types into three big things. So I'm gonna give you a brief look at these typical types. The first one is share deal. Of course, the target is the share. There are two types share deals. One is the share purchase and the other is the share issuance and subscription. These two are very similar but also different. The first, the share purchase. This is the most common type of M&A. The buyer buys target shares from the seller, the shareholder. So the buyer pays the purchase price to the seller and the seller has the control right, so the power to make decision. The purchase price should not be the same as the minority shareholders. Actually, the purchase price reflects the control premium, and the buyer takes over the entire company by buying the shares, so the buyer also takes over the contingent liabilities of the company as well. The next one is the share issuance and subscription. The biggest difference is the seller is the company, not the shareholder. The buyer pays the purchase price to the company, so the purchase price cannot reflect the control premium. That's the biggest difference. And next type of M&A is a business transfer. The target is the business. It's not just the asset of the company. It includes the asset, human resources, know-how, and something like that. In the business transfer, the seller is the company that owns the business. So the purchase price does not reflect the control premium because the premium only goes with the majority shares. And the most important thing is you can buy a specific business, not to take over the contingent liabilities. You can carve out some assets or liabilities which has a list of contingent liabilities. But you must know that you cannot carve out every contingent liability like tax, labor, or environmental liabilities may not be carved out. The process is kind of hectic and complex. You have to transfer everything separately. Every asset contract should be transferred by separate transfer procedure. Also, the business transfer is quite huge event to the company, so it may require the special resolution and other special procedures. Okay, the last one is the merger. Pretty simply, the merger is that two companies become one company. Usually, the procedure is complex and you have to consider tax effect seriously. It is also huge to the company, so it requires special resolution and other special procedures as well. Of course, you cannot care about the contingent liabilities, but unlike the business transfer, the merger does not require the asset, contract, and liability to be transferred with the separate transfer procedures. By the way, in Korea, unlike in the US, a control premium may not be considered because the merger ratio does not be changed by the majority shareholder. In Korea, the merger ratio is usually ruled by the regulations. Okay, so far we talk about the keyword and the general types of M&A. This is what I got today. If you wanna ask about M&A, Korean laws, or any kind of business transaction with Korean companies, just scroll down and leave a comment or just send me an email. Hope you enjoyed the content today. Thank you.